is where it is that we are. Thank you, Jeff, for being part of the symposium. Like I said, now we've reached 90 plus. And interestingly, I don't know whether you saw this mail of mine. I sent it out that Rafael from Mexico has termed it the Woodstock of mediation. So that's an interesting comparison. And it's been, I mean, it's wonderful to have these wonderful people, and everyone has got their point of view. And yours, of course, I'm hoping is also going to look at development of people who can only practice as mediators, like both of us do. So please introduce yourself and please take it forward from here. And like, you can call me in whenever you want to.
Well,
Thanks.
thank you, Vikram. I'm very honored and happy to be here with your worldwide audience. Congratulations to you on the incredible success of this symposium. 92 speakers from all over the world creating this incredible catalog of shared knowledge, and hopefully I'll contribute a little something of value to what you have going here. I'm an independent mediator in private practice. I live in Los Angeles, California. I've been a full-time mediator for about 26 years now, Vikram. And here in the United States, to answer your question, yes, it is possible for people to make a living and support their families by practicing mediation full-time. And there are a lot of people who do it. There are a lot more who would like to do it. And it's challenging, like everything that's valuable. It has its challenges. Finding business on a continual basis, of course, is a big challenge. One thing they don't teach you in mediation training, by and large, I think, is that when your cases last only a day or two at a time, you're constantly needing to refill the pipeline. And how we go about doing that, and the things that work and don't work, and the things that take a long time to work, could fill an entire hour. Although I don't think that's really why I'm here, although we can certainly get into those sorts of things in the question and answer section of the program if that's what you would like. By way of overview, I thought that I asked myself, what could I tell our listeners that's new, that's not the same old thing, that might help them gain some insights on their practice? And it seems to me that the overarching thing that's happened to our practice and indeed our society, and we see it here, Vikram, you're in India, I'm in the United States, we've got people all over the world, is that so much of our life now is online. And online communication, teleconference, video conferencing like this, before the pandemic started, this was kind of an exotic way to communicate. I confess that I had used Skype a few times for conversations with people. I wasn't particularly familiar with it. I don't think I'd ever used Zoom at all before the pandemic and the lockdown in the spring of 2020. And I think it's been a big adjustment. And I think that there are some things that we can learn from it. And I think that there are a lot of questions that still exist because we never stop learning and we never stop changing. We never stop adapting. We never go back. We really can only go forward. And so the question of how we go forward with these new technologies and what effect it has on the way we practice, I think these are some significant questions, things about which we need to think. And let me get the ball rolling on some of the questions and the larger implications, perhaps, that some of these questions raise. So the first question that I think we need to ask in terms of the impact of technology is the timing of mediations. How has the timing of mediations changed since the pandemic and lockdown began? And here I think there's some good news, and I think there are some troubling things on the horizon as well. Let me get into those. In terms of the good news, it is easier to convene mediations than it was before, because people do not have to travel long distances. I do mediations now, particularly in intellectual property cases and commercial insurance cases, where we may be dealing with insurance company representatives in London or the United Kingdom. In intellectual property cases, we're dealing with executives of companies and inventors who are all over the world. I had one case a few weeks ago where I live in California, as I said, in the Pacific time zone, and we had some participants in Taiwan and we had some participants in Australia. People were all over the world. And in the olden days, before 2020, trying to convene a mediation and get people to fly halfway around the world from different directions and coordinating all this, it likely would have taken us months to come up with a date when everybody could attend. Now, however, we were able to convene the mediation on about 3 weeks' notice, finding time when everybody could participate. It caused some curious things in terms of people's metabolisms and what time of day people were participating. I started the mediation at my time, 5 in the morning in the Pacific time zone. It's not easy to go to bed at 8 o'clock at night, but I managed to get enough sleep and get through the day in pretty good shape. And for some of the participants, it was the middle of the previous night. And for other participants, it was the middle of the next night. And so what we have in these mediations that are somewhat easier to convene, you don't know whether to laugh or cry. Somebody is always hungry. It's always mealtime for somebody, and they're taking a break. And somebody got up too early or got up too late, and they're tired, maybe they're a little cranky, and I encourage them to eat something with some protein and get some water and get some hydration and maybe get a little fresh air, step outside if the weather permits, wherever they happen to be, and we get through it. So the timing of mediations in terms of being able to schedule things, I think we have some pluses in that we're able to schedule them more easily. The timing of mediations is also constrained by various other factors, some of which are good and some of which I think are not so good. Let me raise those. I think that earlier this year, there was a crush of mediation, both in my practice and the practice of others. We were really, really busy. And I think that's because in the springtime, when it looked like the pandemic was really lifting, now query whether we're going one direction or the other, but in the springtime, it looked like things were lifting. And I think that there was a desire on people's parts of businesses to get stuff off their plates, to get rid of the old headaches so they could make room for the new headaches, solve last year's problems so they could get on to new problems. And indeed, I think that's one reason people have always come to mediation, because they need to put the past behind them in order to clear their minds, to concentrate more fully and more completely on futures that people want to make brighter for themselves. And so I think that's a good thing. I think that's a very valuable service that mediation provides, that when a lawyer senses that a client is about ready to look at a dispute differently, when a dispute no longer is like a fresh wound, and the client may be ready to make the dispute more like part of the ancient history of their lives. And this happens when new opportunities arise, new challenges, new projects. They just need to get the old stuff done. When lawyers need a little help getting their clients over that last hump to accept the benefits of finality, that the benefit of finality outweighs the disappointment that people may feel with paying a little more or taking a little less in the typical commercial case. When a lawyer feels that a client needs a little help coming to that realization, that the benefit of finality is really worth it. A mediator can really be of tremendous assistance. And I think we always have, and I think indeed in the United States and perhaps elsewhere, that's one reason that the mediation profession exists, because we are another skilled professional to whom lawyers can turn for some help in managing client expectations and helping clients deal with realities, expectations that may in some regards be disappointed, and yet worth it on the financial term in order to get matters behind them. So we've kind of had 2 years of this in 1 year, because in 2020, with courts closed in the United States, there was really no pressure of trial dates, making people settle. There was not, commerce was way off in the many sectors of the American economy. There were fewer new opportunities on presenting themselves on people's plates. But now I think that we're getting back to the normal flow of getting some old situations behind us so that we can deal with new situations. The kind of pressure and the timing of mediation that I think is not so productive is pressure from courts. Courts, I grant you, can be very overcrowded places, and there can be significant delays. And these are very real problems in the administration of justice. I have serious questions, though, about whether courts ordering people to mediations at times when the lawyers themselves are not selecting mediation as a preferred option. I have serious doubts as to whether that's really a good idea. In my experience, once lawyers get a taste of mediation and understand how it works, that mediators don't bite, that we're not there to undermine them in the eyes of their clients, we're there to support them in the good advice they're giving their clients, lawyers generally figure out a way to get their cases into mediation. Let's look at it this way. Before there was any such thing as mediation, and Vikram, I remember those days. I was admitted to practice. I graduated law school 41 years ago, 1980. And in those days, there really was no such thing as mediation here in the United States. And yet the conventional wisdom then as now is that 90+% of all cases settle. I'm sure we've all heard this, no matter where we practice, anywhere in the world. I think we've all heard this. So before there was such a thing as mediation, if 90+% of all cases settled, how did that happen? Well, the lawyers must have found a way to initiate a conversation about settlement. Otherwise, how could it have happened? And lawyers were apparently able to initiate those conversations about settlement by themselves when there was no third-party facilitator, no mediator there. So query, why now should it not also be possible for lawyers to initiate the topic of a facilitated settlement negotiation or mediation without stigma? Lawyers have been initiating those conversations about settlement, getting cases settled without stigma for generation upon generation. So query whether it's really necessary. In my practice, there are some cases that come in and they're just non-starters. And I ask myself, why are these people here? And granted, this is my day job and I get paid for working with them. So I suppose it's not the worst thing in the world, but it's not a good thing either. And it's not why I became a mediator, to preside over or facilitate negotiations that went nowhere and didn't really help people. And in my practice, when I look at the cases that are non-starters and I ask the lawyers, we seem to be having some trouble generating progress here today. How did you all come to decide today was the right day to mediate? The most common answer I get is, well, we didn't actually decide. It was the judge who ordered us to be here. Okay, I get it. When people are not there of their own volition, when they haven't literally bought into the process by parting with some money to pay the mediator and have their lawyers prepare properly, they're really not committed to the process. It's not their idea to be there. They're coerced. I don't think that mediation does not stand for coercion. Mediation stands for freedom, for the free ability of people to engage in self-determination, to pick what to do themselves. When you look at it a little more deeply, the question of courts ordering people to come to mediation becomes even more problematic. Because in my experience, I've been a full-time mediator now for 26 years, Vikram. In my experience, when a case is right for settlement, it has something to do with the state of the record in the court proceeding, but it has much more to do with the emotional state of the client than it does with the factual or legal state of the record. And who knows best what the client's emotional state is? I think it's hard to say that it's the judge. The person who knows best the client's emotional state is their own lawyer. And so the decision of when to mediate should really repose in the lawyers, because as I mentioned earlier, it's the lawyers who know best when the clients are really getting near that point where they're ready to take a fresh wound and make it part of ancient history. On my 2 trips to India, Vikram, in 2018 and 2019, I talked to many lawyers. I had an opportunity to speak to judges and mediators in the Delhi High Court. I met a lot of the people who were mediators in the Delhi High Court. We served together as judges in the Advocate Maximus mediation competition, wonderful program organized by the Pact, the wonderful people there in India, Nishant Laroya, Jonathan Rodriguez, Gracious Timothy Dunna, and their whole team over there at the Pact. They do a great job. And in talking to them and in observing what I could observe of the Delhi High Court, speaking to others, I have some questions as to whether in India you're moving in the right direction in terms of becoming involved too closely with the court system, and whether the proper relationship, the proper distance is being maintained between the court system and the mediation system, if you can call it that. We are, after all, alternative dispute resolution. And hopefully we provide a system that's an alternative to formal adjudication in the court system or an arbitration system. Granted, there's a kind of tacit coordination between them because, at least in my case, almost all my business comes from cases that are somehow touching on a litigation or arbitration system as well. That's kind of the locus for dispute resolution. And we are an alternative to that, right? We are related in a context to that. But I wonder in India whether the situation is too close or maintaining appropriate distance. And again, that's something that perhaps we can determine in or talk about further in the question and answer period that we have. Let me talk next about a difference now that we're online in terms of the selection of mediators. And one question is, are people selecting mediators from a wider geographic basis? A lot of mediators I've talked to say, oh, this is great. Now I'm really practicing all over the country. I'm practicing all over the world. I'm all over the place. And I would like to think so too. And yet, when I talk to lawyers, I regret to say that at least up until now, most of them don't seem to be seeing it the same way. The people who are hiring mediators, they seem to be behind the aspirations of mediators in terms of opening up to this whole world of mediation. And indeed, I find while I'm getting some cases from lawyers in other cities, I always have, or at least I have for the last many years, it has not taken the big boost that I thought it would. And in talking to lawyers about this, it seems that the reason why is that they are interested in having mediators who are familiar with the local court system or the local arbitrators where the litigation is venued. Because remember again, we are an alternative to litigation. That is the thing to which we are alternative dispute resolution. And so I live in California. I'm more or less familiar with many judges in California. And so most of my business still comes from California. Am I familiar with judges in other parts of the United States? Not so much. Am I familiar with judges in the United Kingdom or India? No, not at all. So I understand the lawyer's concerns that a mediator in one place is less able to say, oh, yes, I know old Judge so-and-so. This is how Judge so-and-so typically views these cases, or I've seen a lot of cases like this in this county or this jurisdiction. And so query whether in typical cases, the move to technology is really going to allow us to serve broader geographic markets more commonly. In the largest of large cases, I think those cases have always existed with a more national or international base of mediation practitioners. And I think that the highest of high-end cases, those lawyers in those cases will always be picking from their mediators nationally or perhaps internationally. So that is actually a bit of a disappointment for me and perhaps for others, at least up until now. The other question on selection of mediators is, will there be skills that are more valuable or less valuable in the online environment than they were in person? And here, Vikram, I think we get to the question of the so-called forceful mediator. The mediator who's, in your face and telling you what to do, and I've seen a million like this, and you better do this or you're in trouble. You know the kind of mediator of whom I'm talking. There are more typically retired judges, not always. There are some attorney mediators who are like that as well. And indeed, there are many retired judges who do not practice in this style. So I want to be fair and even-handed and not overgeneralize about the subject. My sense, though, is that forceful in-your-face style, I think it's got to recede in significance as we're online for a variety of reasons. Number one, if you have much experience mediating in high-rise buildings, as I generally do or did in downtown Los Angeles and other cities in the United States, every mediator can tell you stories about when they strategically situated themselves between somebody and an elevator in order to discourage somebody from leaving a mediation. Well, you can't do that online. You cannot get between somebody's index finger and that little red button at the lower right-hand corner of the screen that says leave. Force is not going to get people to stay and make deals when they can leave with one click of their index finger. I also think that particularly when parties are participating from the comforts of home, it's a lot harder to scare or intimidate them. If somebody is in what I call the Coliseum environment of a conference room, where we're all sitting around a table in a boardroom and everybody's put on their best clothes and driven or flown at some inconvenience to be there, it's a pretty intense environment. People are on edge. I sometimes think that ride up the elevator for parties particularly is the most tense moment, one of the most tense moments of their lives, because in that elevator ride, I can just imagine their stomachs churning and then these people just feeling terrible as they think about all the facts and circumstances that led them to be in a litigation situation in the first place. And for most people, being in litigation is pretty unpleasant and pretty stressful. But when somebody is sitting at home, they're probably dressed more comfortably. They're in familiar surroundings. 50-50 that they're wearing shoes. They're probably not wearing. I'd say greater than 50-50. People are sitting there. Their children may be around. Their dog may be sitting next to them, or their cat may be sitting on their lap. And so the idea of scaring somebody when they're in the comfort of their home, I think it's a lot harder to get away with because people are in a place where they naturally feel secure, not in a place, the Coliseum environment of the conference room, where people naturally feel insecure. So my sense is that the mediation styles that focus on empathetic listening, on the things we read about in Getting to Yes, separating the people from the problem, developing options, evaluating those options, trying to come up with the option that creates the greatest mutual gain, making clear, strong decisions in a calm, informed environment. That's how I've always tried to practice. So maybe it's just wishful thinking on my part that this is going to be more successful. But I really think it is. And I think that the forceful few are going to find themselves challenged to get the results by intimidation online that they have gotten by intimidating people in person. So let's talk now about another issue in online mediation that I think for lawyers is a minus, and that's the physical separation. That's the lawyer is sitting in their office or home. Their client is sitting in their office or home. They're not with each other. And this, I think, is a minus because I know that good lawyers, most of the lawyers with whom I work, and I think most lawyers in general are good lawyers. They're putting the client's interests ahead of their own. They're well prepared. They genuinely want the best for their clients. And the clients are making tough decisions because they're being asked to pay more or take less in the interest of finality and all the benefits that finality offers. And I think for lawyers to comfort their clients, to counsel their clients, to break this bad news in a way that's with as little pain as possible, to bring what are perhaps unrealistic expectations down to planet Earth with as little pain as possible. I think that's easier to do in person. I just think that when you're sitting next to somebody, sometimes you put your hand on somebody's shoulder, it becomes easier. You look them straight in the eye. There's something about one physical body being in proximity to other people that allows people to, I guess the word, Vikram, is encourage. I think about that word a lot in mediation, encourage. What does it really mean? I think that to encourage really means to give somebody else courage. And sometimes what we have to do as mediators and what lawyers do is we are literally lending the clients our sense of courage, our sense of confidence in the future. A common question that I'll ask somebody in a mediation if they're encountering this kind of situation, I'll try to be as empathetic as I can and say, I can see on your face that this is a very difficult set of choices for you. I get it. And I'll ask people, can they call to mind other difficult situations from their pasts with which they have dealt successfully? And how did they do it? Maybe it was the death of a loved one or a breakup of a close relationship or loss of a job. You get to a certain point in adult life, Vikram, and we've all had disappointments. And thank God most of us have dealt with those disappointments pretty well. Eventually you get over it and perhaps you're stronger for it. And I ask people to think about such situations from their own lives and what internal resources they found within themselves that allowed them to move on. And I find that it's a little harder to have those kinds of conversations online as compared to having those conversations in person. So I think it's kind of a minus of the online environment. I know that for many lawyers who have ongoing relationships with their clients, represent corporations or other business entities, they have treasured the in-person experience because they've made productive use of, let's face it, there's dead time in mediation when the mediator's doing something else, talking to somebody else. And those are times when lawyers and clients can have casual conversations among themselves. Tell me about your family. Tell me what you like to do for fun. Where do you live? All sorts of things. And those kinds of conversations are a little harder to get going, I'm finding. The lawyers are telling me, in the online environment. It's easier to multitask. That has pluses and minuses. So the lawyers, when the mediator is busy elsewhere, the lawyers can work on other things. Clients can work on other things. Clients are not entirely opposed to that because, frankly, they're happy if the lawyer is turning off the meter and not billing them for the time and billing it to another client for whom they're working during downtime, which might be an hour or more. That almost never happens in in-person mediation. In-person mediation, when you're having that small talk with your client, you're not turning off the meter on client one and working on the meter for client two. So clients are not entirely unhappy with this loss of personal chit-chat because their lawyers are working on other things and billing other files, keeping costs down. But still, there's something to the personal element. And I think that when we're in mediation, it's the personal element that we value so much. You know, it's not like running a computer program and just coming out with a result. It's not an arbitration where there's much less personal interaction. And it's not the kind of mediation, again, the forceful few type of mediation where they read the mediation briefs, decide about where the case is going to come out, and then relentlessly drive and force and perhaps even coerce people to come to the result the mediator wants. It's not a style of mediation with which I'm comfortable. And again, in the online environment, I hope that's a style of mediation that kind of falls off. I think it will. And if we're right that the kind of mediation that we offer is superior product, I think the online environment may help certain elements of that really shine. Final thing, I just wanted to say a word or two, Vikram, about the effect of technology, the fact that we're here in Zoom land or one of the other online platforms for almost all our mediations. One little notice thing about it that I think contributes to the civility of mediations is that these online platforms, unlike your telephone, will accept only one voice speaking at once. So it's a lot harder to interrupt and speak over each other. When you're in a room together, it's physically possible for everybody to be emitting sound at once. In these online platforms, only one person can be emitting sound at a time. And so I'm finding fewer interruptions. I'm finding people are a little more polite, in many cases, much more polite, because we just can't speak over each other. And the technology is something that I think we've all learned how to use reasonably well. A year and a half ago, we were fumbling around with it, and it was awkward to put people in breakout rooms, and people couldn't figure out how to unmute themselves. And it was just, well, let's face it, Vikram, the spring of 2020 was just a crazy, anxious, stressful, there was just a lot of dreadful stuff going on when the lockdown started and the pandemic was escalating. But now, Vikram, we've had hundreds, maybe thousands of conversations online and on Zoom. And I think people are much more comfortable with it. And Just imagine if you had never used a telephone before, as perhaps our grandparents or great-grandparents didn't. First time you had a telephone call, it must have seemed terribly awkward. And now we grew up with telephones. I think everybody on this line grew up with telephones. And whether it's a smartphone like we all have or an old-fashioned handheld phone, we all have great comfort having very personal and sensitive and emotional and intimate conversations with people on the telephone. We all do it. And I think increasingly we're going to become comfortable having those kinds of conversations on Zoom and the other online platforms. For my children who are in their 30s, this is second nature. They had been using WhatsApp and Skype and many of the other FaceTime and many of the other online video platforms for several years before the lockdown and pandemic. And it was really no great transition for them. Baby boomers, I think, have caught up. So I think that the future is bright. Do I look forward to going back to in-person mediations? Yes, I do. I've been to a couple of professional conferences in the last couple of months, and there are some awkward elements to them. People don't know whether to shake hands or bump elbows or simply acknowledge each other with a bow. And many people are wearing masks at these conferences, so it's harder to see people's faces. But still, there's something about being back in person with each other, Vikram, that's just terrific. And I think that we will go back to having some in-person mediations in time. I should say we'll go forward to having some in time because they will continue to be different. Social distancing will be different. Our ability, our willingness to be in very close physical proximity within a foot or two of each other, it'll be a while before we're willing to come back to that. Will we still largely be online? Yes, I think we will, because again, if you're doing cases where people are having to travel, other than in the largest and most exceptional cases, people are not going to want to travel. It's just not going to happen. There are many companies that are still prohibiting their executives and personnel from traveling, and that's not going to change for a while. And what I'm finding is that if one side is not able to attend in person, they're requesting that nobody attend in person. And what I'm hearing from people is, we don't want the rest of you sitting there in person talking about us behind our backs, and we're kind of the odd man out, odd person out. So I think we're largely going to be online in mediation for the foreseeable future. I have some in-person mediations. They'll be different, and it'll all be good. When people have a need to settle cases, to put things behind them for personal reasons, financial reasons, emotional reasons, whatever it happens to be, doesn't matter what the medium is, people will find a way to get those matters put behind them. And as long as people have trouble putting those matters behind them by themselves, there will be need for mediators. And I think everybody on this line agrees that's a good thing. I think finally, I think we should keep in mind that trying too hard to compare in-person and online mediations is just not a good idea. We shouldn't spend a lot of time agonizing over it. Think about it as if you're trying to compare plays, going to see a play, which is an in-person performance, versus seeing a movie, which is a video. You can see movies online. Plays are good. Seeing a dramatic play in person is good. And seeing a movie is good. They're both good. They're different, and that's okay. And they each have their benefits and their detriments. Movies cost less money to go see than plays. There's typically more choice of movies than plays. Plays have an immediacy to them because you're in the in-person experience. So just as plays are wonderful things and movies are wonderful things as well, I think that in-person mediations are wonderful things. And over the last year and a half, I have come to accept and learn and celebrate the fact that online mediations are wonderful things too. I hope this gives us some food for thought, Vikram, and I'm happy to engage in conversation with you or anybody else online with us here for the remainder of our time. And again, I thank you so much for the opportunity to present, and I congratulate you on the incredible accomplishment of putting together this symposium.
Thank you very much, Jeff. And your practical insights are amazing. I mean, all those things that you brought out, because largely otherwise you have discussions on the general things happening in terms of the law and other things. These finer things sometimes get missed out. But let me tell you, I am totally comfortable, maybe a little too comfortable on the online space. So for me, I'm not looking at any physical kind of thing happening. I don't know at all. But right now, I think not at all. So that definitely is something that I'm looking at. But interestingly, let me tell you how I've been talking about this is that India missed out on the entire pager aspect. US went through an entire period, a long period where you had pagers. Mobile phones came in much later. India missed out on that because by the time we got pagers, the mobile started coming in. So similarly, I'm looking at mediation that because not much has happened. I don't even, I mean, I'm not even going to talk about the court related thing. As such, in mediation, as we call it, private mediation, and you'll hear me a lot of times saying that that's the only way mediation should have been. Court is just should not have been part of that. But okay, so let's call it private mediation. That hasn't happened. So I'm looking at that. Let that happen only in the online space and let people think that mediation happens online. I'm trying to, I mean, promote it that way because a lot of factors. I mean, cost is one factor. You can understand, I mean, in terms of distances and everything that people go through, I feel that that is quite workable, quite workable. I don't know how you're looking at that.
In terms of online mediation being workable?
I mean, as a long-term thing where people, for you, it's different. I mean, for you, the concept is that mediation has been around for so many years and people have been doing it. So mediation is linked with physical. I am saying for us that aspect might not even be there.
It could be. You might skip it altogether, Vikram.
Yeah.
I don't have any. I'm no expert. I know I've been to New Delhi. You live in New Delhi,
Yep.
right?
Yep.
And I've been to Mumbai, which is an even bigger city than New Delhi. And let me tell you, in Los Angeles, where I live, it can take forever to drive from one end of town to the other. And New Delhi is even bigger, and Mumbai is even bigger. And don't get me started on the way people drive in your country, Vikram. It's a thrill a minute to be in a car in New Delhi or Mumbai. But even in Los Angeles and other big cities, just getting from one end of the city to the other. In New York, I have friends who say, getting north and south is easy from one end of, they can go from Midtown to downtown Manhattan on the subways. North and south is pretty easy. But they hate going east and west. They hate going from the east side to the west side. It's just a lot harder. And so in big cities where getting around is a hassle, I can see even people saying, I'm not going from one end of Manhattan to the other, or I'm not going from one end of Los Angeles or New Delhi or Mumbai to the other, because I'm here in my office or my home. And yes, we lose some things, but we gain some things too. And all in all, well, as I said earlier, when cases need to settle, when people have motivations to settle cases, they find a way. So you may be right.
Yeah, because the way I look at it is that people, like you said, have become so comfortable with the whole video conferencing thing now, because this might not have been the same before the pandemic, but now they're comfortable with it. They've used it, seen the convenience of it. But one thing I have to clarify, Delhi is a larger city and it has more of a population.
Oh, I thought Mumbai was bigger.
Mumbai, look,
Okay.
the thing is that there is a bump, the Mumbai, as in the city, there are certain limits, there's certain municipal limits where go, there is a larger portion which is considered Mumbai
Ah,
by people, and so as such, we are a much more spread out city. I mean, I think
yes.
entire Mumbai is about 600 square kilometers. We are 1400 square kilometers. We're much bigger.
Well, I didn't mean to offend you, Vikram, and I hope I didn't. We're
Oh,
both.
why I'm telling you this is very important. Why
Yeah.
I'm telling you this is because people in Delhi also don't know how spread out Delhi is. We're really spread out. I'm saying 1400 square kilometers, or almost 1500 square kilometers. If you are, it's a huge space. So a lot of people, I'm saying my daughter would not know how big the city is.
Yes, and both cities have over 20 million people, don't they?
Yeah, we're about 20 million. Yeah.
Yeah.
Yeah. So that's it. It is, yes, it is that. So in
Yeah.
that space, definitely. But Jeff, little bit, of course, look, you became a mediator and you're doing your work practicing now, but a little bit into history. Do we have anything that you want to take us back in the US as to the whole concept of mediation being part of society in some way, how it started? And you want to anything on that you want to tell us?
Well, I think the concept of mediation, Vikram, has been with us forever. The idea of having people help other people negotiate problems. We didn't always call these people mediators. The role of clergy in various faith traditions, various faiths, I think has for a long time included helping people, whether married couples in trouble, divorcing situations, or business situations. I know I'm Jewish. Rabbis have long done things along those lines. And so clergy in various faiths, teachers, just think about the role of teachers in helping students get along, or breaking up fights. Teachers have been mediators with village elders in various traditions. So we've had people who have served in the role of mediating. Parents and grandparents often serve as mediators in family issues and other issues in the community. So in the United States, I think the way it's become more institutionalized, it first became institutionalized in the context of what we call community mediation, community centers, where people were dealing with neighbor to neighbor disputes, small business disputes in the communities, and people were being trained in dealing with those kinds of disputes. And then, really a little before my time in the field, it grew into the idea that this could work in commercial contexts as well, litigation contexts, and that people might actually be able to make a living, support themselves doing this kind of work. And so the training in commercial mediation was initially very similar or the same as it was for community mediation. And this, as with most things, had good and bad aspects. Good aspect was that there was a set of skills and techniques and the way to teach these skills and techniques that was built in. It was right there, and it was easy to use. The challenge is that it's not a perfect fit. So, for example, in community mediation training, the purpose of a joint session has generally been defined as setting the agenda, finding out what the dispute is about, and the agenda for the negotiation. In those kinds of cases, the mediator was not dealing with lawyers, was dealing with neighbors or people in a community dispute. There were no opportunities for briefs to be submitted, mediation statements in advance. You just had a mediator be in a small claims court in a courthouse, perhaps, or a community mediation center, just kind of parachuted in without any preparation. So you need a joint session to find out what the dispute is all about and set an agenda. In commercial cases, you have a lot more opportunity to prepare. You have lawyers involved typically. You can get mediation statements or briefs. You can have phone calls, or nowadays more video calls with people to prepare for the mediation session. And so the idea of the joint session to set the agenda is kind of an odd fit in a commercial case. The number one item on the agenda in so many commercial cases is how much money does the defendant have to pay the plaintiff in order to get a release of the plaintiff's claims against them. To a lot of lawyers and a lot of people, that's the alpha and the omega. That's what the mediation's about. You hardly need a big joint session to define that. And so I think this has caused us in the United States, many parts of the United States, people have gotten away from joint sessions altogether, have overly abandoned the joint session because they had for a long time devolved into the sorts of presentations lawyers would make in a courtroom or arbitration. They turned out to be too inflammatory and argumentative. People would get too upset, at least in the in-person environment. Perhaps they won't get as upset online with their cat on their lap or their dog next to them. And in the United States, we've abandoned, or many mediators in many areas have kind of abandoned the joint session just through the shuttle diplomacy, caucusing and going back and forth. Parties don't ever see each other during the day. I think this deprives the mediation process of a lot of its richness, a lot of the real benefit that mediation can give for the self-determination that comes from being fully informed, from in-person communication, getting information unfiltered. I think a lot of mediation in the United States has lost much of that. And so I personally try to do what I can to have different kinds of joint sessions, not the plenary session, not a session for setting the agenda, but rather once we've set the agenda through the preliminary work of getting briefs and having calls with people, once we've set that agenda, focusing in on the keystone issues and finding out what it is that's really keeping people apart from each other, and then zeroing in on those to the extent we can, in the hope that clarifying those issues will allow us to make progress in the negotiation and create some space for the parties to consider settlement options which perhaps they had not considered before. I hope that answers the question.
Yeah, it does. I mean, but I'm just getting you back to that historical perspective, and how has that? I mean, because look, in terms of the U.S., obviously, it's such a large country. I mean, not as large in terms of population, might not be there, but in terms of the area, so you have smaller towns, you have a more rural population. So, do you see this history of mediation being part of society, be it the clergy or whoever? Has that culture, is it still there in those areas? I mean, do you see any of that?
Well, I can't speak for the whole United States. I can barely speak for myself, Vikram. But my sense is that just as people, my sense is people have always called on third parties to help them get through times of conflict. I don't think human nature is going to change, or at least what we consider human nature in the United States. Perhaps it's different in different cultures, but one way or the other, people in conflict often need some help getting through it. And whatever form that takes, I think it's never left us, and I think it never will.
Well, actually, when I look at the figures and look at basic Google search on what's happening in terms of the community mediation centers and the courts, what I really want to find out and get a little deeper into, you say we 45 years, we've had mediation and all that. But when I look at the community mediation centers, it says that 400 community mediation centers and 400,000 matters go to those community mediation centers. On the other side, I do a research on the court system. It says 100 million cases are filed in the trial courts in the US. I just can't understand that. Why this disparity? I mean, if you've been able to develop mediation in so many years, why has that not reached a stage when it is something which people go to mediators first and courts later? But this seems to be the other way around, and which you, in a way, you've also put it there that the lawyers take it through and all that. So where is that?
My sense, I can't speak authoritatively to this, Vikram. I'm not a expert on all world cultures, or I don't want to get out over my skis, as the saying goes. I think the United States is a very legally oriented country. I think that law, formal law, legislation, the court system, it plays a very big role in our culture. We have lots and lots of lawyers and lots and lots of courts, and they get used a lot. And why is it that our country perhaps has developed in a more legally oriented or more formally legally oriented way than some other countries? Gosh, I think you have to go ask some sociology professors at the top universities those questions, Vikram. I'd like to know the answer myself.
Jeff, you have so many nice practical insights to give us. I needed your practical insight into this because you've been out there. I feel that if people have had a good user experience from mediation, and in 40, 45 years, I'm sure that lots of people should have had good experiences. It should just spread out that, look, this process works. Let's go to a mediator. Let's get this sorted out before we go into court. I'm trying to understand why that has not happened. I mean,
Well,
how do you see that?
maybe it has. Maybe in many places it has. For example, in employment law in the United States, the Me Too movement, particularly in the last few years, there's a lot of instances, some very terrible instances of sexual harassment that have come to light, and the lawyers representing the plaintiffs in that area know that these allegations are explosive. With senior executives of companies involved, they could attract tremendous publicity, and the publicity doesn't really do anybody any good. It doesn't do the defendant any good. And as far as the plaintiffs, mostly women, are concerned, but whether they're women or men, having these subjects aired in public, the fact that they were involved in this sort of situation, and nobody really wants that, the headline of the newspaper, and whether you're a man or a woman or a plaintiff or a defendant, at least the way I see it. So there are a lot of these kinds of cases that do get mediated before a lawsuit is ever filed. And that's for a whole variety of reasons. Well, not the least of which is that it's better for everybody involved to keep this out of the public view. It's not uncommon in other sorts of dispute situations for lawyers to send letters. Hey, here's a draft complaint. We're going to file this in 30 days unless we can work this out. That's a common situation among American lawyers as well. Again, though, Vikram, there's a lot of emotion that goes into it. You oftentimes get plaintiffs or prospective plaintiffs who are just angry. They thought take a personal injury case where someone has, God forbid, lost a limb or an eye or suffered some terrible injury. The idea of make nice, let's just settle, let's just put this behind us, that may not be emotionally appealing to a prospective plaintiff. A prospective plaintiff may at that point be so filled with rage or anger or other emotions that the idea of sitting down for a cool, calm negotiation and working this out in a rational way may not appeal to somebody early in the life of a conflict. That's part of it too. When I was in India and I spoke to the Delhi High Court, we talked, among other things, about the work of famous psychologist Elizabeth Kubler-Ross, her famous book on death and dying, where she talked about grieving for loss and the basic stages: denial, anger, acceptance. And in a sense, prospective plaintiffs in a lawsuit are grieving for a loss. They may be a loss of a physical limb or something. I don't wish these sorts of things on anybody. Even in a commercial context, people maybe have lost a business opportunity, something that they thought would make them wealthy, and it just didn't turn out that way, or they've lost a career opportunity. And they go through the same stages of grieving for loss: denial, anger, acceptance. And when somebody is in an emotional state of anger, a lawyer saying, well, 90 plus something percent of cases settle. Why don't we just sit down and talk about this? That's not going to be appealing to somebody who's in a state of anger. And they need to work through that anger and get to acceptance before, I think, they're really emotionally ready, willing, and able to have the kind of conversation we typically have in a mediation situation.
But Jeff, on the court system, I will definitely discuss that with you. But before that, there is this, like Michael Lang talks about how the whole practice of mediation has changed and he's not very happy with the deal making and all that. What have you seen in terms of the changes in the way mediation is practiced?
I think some of the changes, Vikram, are the things we discussed earlier in the webinar. And I think that we have a saying in the United States, perhaps you have it in India: the customer is always right. And whereas we as mediators may want to have conversations of one type in our mediations, our customers may want to have conversations of a different type. And we can't force them to have conversations that are different emotional tone or temper, or delve into different or deeper, more personal, more intimate issues than they're ready, willing, and able to have. And so if people are willing to have conversations at one kind of level, I think we should be willing to engage at that level. And if clients want what we might consider a more shallow or superficial or a deeper and more intimate conversation, I think a good mediator is prepared to go that way too.
Perfect. Perfect. So you said the way, the need of whatever the need at that point is, the mediator has to go by that. Perfectly all right. But look,
Vikram, you talked about having full-time professional mediators. Is it possible to do this and make a living? Well, yeah, it is. You got to be responsive to the marketplace. You've got to be responsive to the needs of the clients. You may be an opera singer, but the market for opera tickets may be quite limited in a community, right? Who buys opera tickets? Let's face it, it's a rather elite taste, right? If you look at the number of opera tickets that are sold in society versus the number of tickets that are sold to NASCAR, car racing, as a form of entertainment, I assure you, many more tickets are sold for NASCAR than for opera. So if you want to go into the entertainment business and you say, well, should I open an opera house or a car racing track? You may find you're going to sell more tickets if you open a car racing track. There's nothing wrong with being responsive to the needs, wants, and desires of other people. Indeed, that's what capitalism is based on, right? People meeting the needs of other people. And in terms of self-determination of the clients, that's what mediation is supposed to be based on. And because we as mediators may have a taste for certain kinds of conversations that we like, and we may offer that to people, I don't think that gives us a right to order or mandate or require those kinds of conversations. Peter Robinson from Pepperdine told a great story in one of the first mediation trainings I ever took about a faith-based mediator. And a divorcing couple comes in to talk about the faith-based mediator, and they say, we want a divorce. And the mediator says, you need to forgive each other. And the couple says, we want a divorce. And the faith-based mediator says, it would be so much better if you forgave each other. And the couple says, hang on a second, we want to go out in the hallway. And as Peter tells it, the couple comes back in out of the hallway and says to the faith-based mediator, okay, we forgive each other. Now can we have a divorce?
Good.
You know?
Yeah, that's the way it is. The user
Yeah.
decides what they want.
Yeah. I mean, this, let's say you run a restaurant, right? And uh, people like spicy food or they don't like spicy food. Well, if you come into a restaurant and say, as I did when I was in India, I said, could you please make it a little less spicy? If the chef said, well, we make spicy food around here, I would have left the restaurant. But by and large, in the restaurants I was in New Delhi, Mumbai, and other places, when I said, listen, I'm just a middle-aged American guy, and I'm not accustomed to this spicy cuisine you have in India. Could you please make it less spicy for me? Well, generally speaking, restaurants did. There was one restaurant in New Delhi where the people said, "Sir, we are a spicy food restaurant, and we just don't think we can make food to your liking. We can recommend to you some other restaurants in the neighborhood." This is around Connaught Circle. We can recommend to you some other restaurants with more European type menus where we think you'll be happier with the food. And I appreciated that. But if you run a restaurant, you want to serve a lot of people, you have to serve the kind of food that people want to eat. Yes, can you influence their tastes somewhat? Yes, you can influence people's tastes somewhat. But can you get people in at least in a short period of time to change their tastes radically? I think that's a tough sell, Vikram.
But picking up from there, I mean, because look, I'm a very major critic of the whole court system and mediation in the court system. So in the food example, the point is someone goes and wants to have junk food. And we call it junk food, whatever. That's might not be junk for people. So let's
We have
just
it
say,
here. We have it here too.
okay. So if someone wants to go and have junk food, and you tell the person, no, you have to go home and cook your food. They said, look, I came out to eat food, whatever the food might be. I came out to eat food. And no, you have to cook it yourself. So I'm saying the court system is the same thing. The person came to the court and said, look, I want a decision by the court. And the court says, no, you must go for mediation, and forcing them to go through mediation. And the fact is that the whole mediation process, the whole everything being free for people, how does the profession develop in such a situation? I'm really, I criticize the whole thing a lot, and I'm very vocal about it. So I'm not going to pull you into all that, because definitely you are in touch with people in the judiciary and everything here. But I have obviously a very strong view on that. So I won't get totally into that part. But from your experience in the US and the court system and the issues that is creating for mediators, one is for the mediation as mediation in the eyes of people, that they related to courts and free. That's one part. What about the mediators themselves, the development of the profession? What do you look at? How do you look at that?
I think it poses some challenges for the development of the profession, Vikram. I think that in terms of my own professional development as a mediator, one of the biggest days in my career was the day that I just took myself off all those court annexed panels. I had been on those panels for many years. And yes, I got a flow of cases from those panels. And I had I had stuff to do, I had mediations to do. And I was telling myself that I was gaining experience and maybe these people would come back with paying cases and I was honing my mediation skills. And after a certain number of years, I realized I was being a chump, because what was happening was that in those panels, you have to work a half day for free or at a much reduced rate. So what I found was happening was people were continuing to call me back over and over and over again, picking me through that court panel and getting a half day for free. And basically, instead of being able to work a full day and charge for a full day, I was working a full day, but only getting paid for a half day. And I would ask these people, I'd say, you've used me 3, 4, 5, 6 times for free through these court panels. Why don't you to hire me in the private marketplace now? And the answer was always the same. Why should we? You're on the panel, you're giving away your time. You're the one who put yourself on the panel. If you're the one putting yourself out there for free, why shouldn't we have you work for us for free? And I thought about it. And I thought, they're right. I'm a chump. I'm the one putting myself on the panel. The fact that they're using it shouldn't be held against them. It should be held against me. So I got myself off all those court panels. I figured after so many years in the practice, Vikram, I didn't have to give away free samples anymore. If there were lawyers in the relevant communities who didn't yet know me, I was going to have to find another way to reach out to them other than continuing to give it away for free. And did it cause a dip in the number of cases that I was handling? Yes, it did for a while. And that was frustrating. And then eventually it built back. And I have eliminated the problem of people taking advantage of me, of being the only person in the room. They were taking advantage of me at my own, because of my own actions. I put myself in a position where they could take advantage of me. So it was my fault, not theirs. The continual sitting in a room where everybody else is getting paid hundreds of dollars an hour and you're working for free, it got to a point where it was rough on self-esteem and visions of self-worth. And it was just not worth it to me anymore. And the practice has ups and downs, Vikram. There are still slow months and there are slow quarters, and then there are months and quarters where business just comes cascading in. This is what happens when cases just last a day or so at a time. There can be, difference of one or two more cases is the difference between a very busy month and a not so busy month. It's those last couple of cases. So there are ups and downs. And over the years, as I say, I've been doing it 26 years now, you pretty much learn to live with those sorts of things. It's always frustrating when you're in a lull, which happens sometimes, and it's always exhilarating when things are busy. You say to yourself, oh, finally they appreciate me. And then when things slow down, it's, oh my gosh, what am I doing wrong? Have I terribly screwed up somehow? But it's, this too shall pass, as King Solomon's ring said about both the good times and the bad times. King Solomon's ring had two sides. And on one side was an inscription for the good times, and on one side was an inscription for the bad times. And the inscription for the bad times was, this too shall pass. And the inscription for the good times was, this too shall pass. So these are the ups and downs of life.
Now, the interesting thing that you brought out, I told you that clip that I saw with that, I think the Beverly Hills, I think Bar Association, wherever it was, that difference between free and pro bono that you brought out, I think that is very important. That the fact that you're giving it out free, and these are people who can actually afford to pay, because that is something that we have to start discussing that, because of the fact that with the court system and the pendency, that the self-interest of the judiciary is that they should go on for free. And even if they want to charge, they might be wrong to charge, because you are telling them to go through a process which they did not come to the court for. So whether you can tell them to pay for something, that by itself can be challenged. I mean, that's another process altogether.
I don't think court systems should really be permitted to charge people for mediation. Exactly. Because I assume it works the same in India as the United States. People pay taxes to maintain the court system, and then they pay filing fee for access to the court system when they file their lawsuit, or when they appear as a defendant, they have to pay a fee as well. And this is the public system of justice. And when you go to court, in the United States, you have a constitutional right to a jury trial. It's exalted in the Bill of Rights to the United States Constitution. For a court to say, no, you have to go and pay someone market rates outside of the court system before you can have your constitutionally guaranteed jury trial, I think that's very problematic. Similarly, we have provision in the United States Constitution right against self-incrimination in the Fifth Amendment. That's famous. And so because we guarantee people the right against self-incrimination, we don't allow police officers to beat confessions out of people. Well, we shouldn't allow mediators to beat settlements out of people, and we shouldn't require undue burdens on the constitutional right to a jury trial by making people go to the private marketplace and pay. That's why I keep coming back to the theme, Vikram. Lawyers know when their clients are ready to put cases behind them. Before there was any such thing as mediation, lawyers figured out how to initiate unfacilitated settlement discussions. Lawyers and their successors, now that we're in a different generation, should be able to perpetuate that skill of being able to initiate settlement conversations on their own when the time is right, with a mediator or without, as the case may be. And to the extent that we can maintain a healthy distance from the court system, just as in the United States, we maintain a healthy separation between church and state, benefits both the church and the state, religion and the state. I think it benefits both the mediation system and the court system for there to be a healthy separation. And the distinction between free and pro bono, there's a lot of mediators out there who look to the court system for the cases they mediate. And indeed, when I started my practice, I did too. How was I going to cut my teeth? It was through these court annexed cases before it worked until it didn't work. And there's a difference between working for free and working pro bono. Pro bono in the United States means working for poor people. And you think about the kinds of cases where pro bono exist, landlord-tenant cases, the neighborhood community centers, community justice centers, things of this nature. People who can't afford lawyers should, in many cases, have access to some legal representation pro bono. That's a wonderful thing. And so many law firms and lawyers work for the underprivileged on a pro bono basis. But if you work without pay for multinational corporations, wealthy people, big insurance companies, public utilities, things of this nature, well, they're not entitled to anything for free. They can afford it. And if you're working for them for free, for your benefit to develop your career and cut your teeth and get some experience doing these kinds of cases, or earlier in your career, giving away the proverbial free sample in the hope it leads to business, that's not pro bono publico. It may be pro bono mediator. You may be doing it for your own good, but you're not doing it for the good of the public. And keeping in mind the distinction between that which is truly pro bono and that which is just free, I think is a liberating thought for mediators, because it will get mediators to do true pro bono if they want to do true pro bono, but not to be sucked into the idea. I think that ultimately in the long run hurts them, that doing all this stuff for free is really going to benefit them. The experience, anecdotal, true, anecdotal, but the anecdotal experience I have is that the kinds of lawyers who just want free mediators then don't go on to pay you when you get sick and tired of working for free. They just move on to the newer crop of trainees and the people, the newer new entrants to the marketplace who are cutting their teeth, and they continue to take advantage of that opportunity that's provided for them, that we provide.
Course, yeah.
So be
Whole
careful.
circulation. Yeah.
Be careful how long you stay on those free panels. I would say that to mediators in any place where there's a free market alternative.
Look at the way, because the way I'm looking at it is that, like you correctly said, that for the court to tell a litigant that you have to pay for a process that they did not come to the court for, is incorrect. They should not, you cannot do that. And on the other end, of course, you have a pendency where this matters in, in India can go on for 10, 20 years.
I
So in
know.
that sense, I've been very vocal about this, that the courts actually should say that we deny justice, because justice delayed is justice denied. But they get away with it because we still, I'm telling you, that is that colonial mindset that the courts are always right. They can do what they want. No one really talks about them, criticizes them. I do it because I'm not connected with it at all. So I can do it and I can see it in front of me. There's some senior mediator. He said he started a mediation center with some other lawyers, doing well. Then the court starts a mediation center and they have to close this down. So for me, the private practice has to develop. Instead, it's working on the reverse. Private practice, people might have to close down. So I'm just looking at it that I mean, things that have already come up in the US, if they have on these issues, which of course that's why I was wanting to take you through that. If there was something that you had to tell us how we should not go about it, which is what you kind of have put across. But the other thing is about, look, we have a uniform law, very good law, where confidentiality is one of the things which is protected, which you have gone around saying it is not protected in the US. So we have everything for us. We have that law protects the confidentiality, protects without prejudice. The mediator cannot be called as a witness. It's a uniform law for the entire country. But for some reason, the people are told there is no law on mediation because it's just called conciliation. There is a, I mean, that's why I put out, as I sent you the theme. I said, look, Singapore Convention has this broad definition. India signed it, and it is in principle accepted as a definition by us, that this is the definition of mediation, and it's broad enough to cover our conciliation. So we have a law on mediation. So I think the problem is awareness on that end. So I don't know whether these issues, I mean, like confidentiality, is it something that created an issue with you? Did people ever talk about it in mediation? Was it taken for granted? How was that?
I think, Vikram, the confidentiality issue in the United States is kind of a tempest in a teapot. I don't think it's all that important, to be honest with you. I think mediation was initially conceived as a place where people would come and bare their souls and tell their deepest secrets, and there'd be a lot of Kleenex and all that. And there are some cases that are like that. I can't, again, I don't like over generalizing. Not all cases are one type or another, but in the business and commercial world, the business to business world where I operate, by and large, people don't come in and bare their souls and tell their deepest secrets. They're there to try to make deals if reasonably possible. And they're there sometimes to talk about the personal and emotional considerations that enter into it. Sometimes it's just all money. And in terms of people revealing weaknesses in their cases, particularly with lawyers involved, people are very cagey and very strategic about this, in my experience, by and large, where nobody comes in and says, nobody, here I will generalize, nobody comes in and says, Jeff, they don't know about this down the hall, but if they ever find out about this document or this witness or this case, whatever, we are sunk. So, don't tell them, but there's this smoking gun here that if, God forbid, they ever find out about it, it's big trouble. Nobody ever says that. Why? Because there's a greater than 0% chance that the mediator will leak, will disclose. Just inadvertently, unconsciously, subconsciously, who knows why. So people don't say those things. And the idea that people need confidentiality to have candid, open, totally open conversations in mediation, well, people don't, in my experience, don't have these totally candid and open conversations in mediation. They have cagey and strategic conversations designed to help them get the best result possible under the circumstances. So query, what is it that we are protecting? for many years in the United States, we've had a general rule that in a settlement negotiation, offers and demands in compromise negotiations cannot be introduced in evidence to prove the strength or weakness of the claim being negotiated. And for generations, that's been enough to get 90%, 90+% of cases settled. Now, in the world of mediation, all of a sudden, it's no, we need all these greater protections. And I don't think that it helps. I just don't see a need for it, really. And the problem with it is that it frustrates the rule of law, it frustrates the administration of justice, because there can be torts that occur in mediation, wrongs that occur in mediation for which there's no remedy because of the application of the confidentiality laws. And the three torts that can occur in mediation, you can have malpractice by a lawyer, you can have malpractice by a mediator, and if insurance companies are involved, you can have what we call in the United States insurance bad faith. That can take place in a mediation too. I don't think that any of these torts take place in mediations very often, to be honest with you. And there are not going to be many cases at all where redress is needed for such torts. But if you're the one who's the victim of the tort, you want your remedy. And because of the confidentiality laws, you may not be able to get a remedy for something that is clearly tortious, that's clearly wrong. So query, why do we suspend the rule of law in mediation and allow there to be torts which will go unremedied in order to get this confidentiality, which, at least in the world where I operate, doesn't seem to provide much of a benefit at all? Lawyers in my practice typically, they don't ask many questions about mediation confidentiality. There are cases, I did one case, Vikram, I did it in Chicago, Illinois, in the days before the pandemic when we would sometimes travel to do mediations. And the case was not pending in Illinois, the case was pending in the federal court in Minnesota, not too far from Illinois. But it was easier for everybody to get a flight into Chicago. So that's why we did the case in Chicago. And the case was pending in a federal court, not a state court. You know, we have a federal system in the United States. And there were a lot of very high-powered lawyers involved. It was a high-stakes case, a lot of really high-powered, excellent lawyers. And I asked them, just casually during the mediation, which jurisdictions mediation or confidentiality or privilege law applied to this mediation by operation of law. Well, there was one thing on which everybody agreed. They agreed that just because I am from California, I did not bring California's state confidentiality law to Illinois with me. Everybody agreed on that. About a third of the lawyers thought that because we were physically present in Chicago, Illinois, the state law of Illinois would apply, the Uniform Mediation Act. Okay. About a third of the lawyers thought that federal law, Federal Rule of Evidence 408, offers and demands cannot be introduced in evidence to prove the strength or weakness of the claim being negotiated. They thought that Federal Rule of Evidence 408 applied. Okay. And then there was another third that said that even though the case was pending in a federal court in Minnesota, under what's called diversity jurisdiction, the governing law in that case was Minnesota state law. And so they thought that Minnesota's state confidentiality or privilege law would apply to this mediation. But those lawyers who thought Minnesota state law would apply were not from Minnesota. So I said to them, it's quite interesting. You think Minnesota state law applies. Well, what does Minnesota state law provide? And none of them knew. So I don't think that lawyers really predictably rely on any particular state's confidentiality or privilege law. I think they're cagey and they don't say things which can otherwise be used against them. Now, if the other side knows some stuff that's damaging to your case, yeah, you got to deal with the weaknesses of your case that the other side knows about. But do you go about volunteering weaknesses of which the other side does not know? I don't think that's responsible lawyering, and I don't think many lawyers do that. The whole confidentiality thing in the online environment is much more complicated than that, because when you've got people in different jurisdictions, how do you really know where the mediation, quote unquote, takes place? Where is our conversation taking place right now, Vikram? I'm in Los Angeles, California. You're in New Delhi. Where does this conversation take place? If there was an issue as to if we were in a mediation and the confidentiality of this mediation were being tested in some court someplace, would you urge the judge to apply the law of California, the law of New Delhi? If the confidentiality of our mediation was being tested in London or New York, would those judges have the prerogative to apply the local law of London or New York? In New York, they would have the prerogative to apply their local law. I don't know about mediations in other parts of the world, but promising clients that a future court is going to protect the confidentiality of your mediation is a risky thing to do, because courts, at least in the United States, do have the prerogative, the discretion to apply the local law of their own court rather than the law of where the mediation took place. So that eliminates a substantial degree of reliable confidentiality to your mediation.
Yeah. Look, Jeff, I've taken a lot of your time, but just a little bit on the regulation of the profession, because of the Singapore Convention, the countries are drafting their law. Is there something that you want to tell them about regulating the profession?
I have more questions on this than I do answers, Vikram, because the Singapore Convention relates, as I understand it, to having your mediated settlement agreement enforced in a court, right? That's the subject matter of the Singapore Convention. So in most of the commercial mediations, defendant pays a certain amount of money and the plaintiff gives a release. Yes, there are some cases that have prospective terms of implementation. People have to do licensing of intellectual property over different periods of time. But most commonly, how much money does the defendant pay for a release from this plaintiff? And if the defendant doesn't pay the money, then they don't get a release and you go back to litigation. That's what happens. So almost always the defendant pays, or its insurance company pays the money, there's a release and there's nothing to enforce. So the question that I have, and maybe it's different in other countries and other parts of the world, is what is the real practical significance of the Singapore Convention, given that, at least in my experience, it's a rare occurrence indeed when you would have to take a mediated settlement agreement to court for enforcement.
I'll tell you how it works, because first of all, in a country like ours, to execute a decree much easier than enforcing a contract, because you file a suit for specific performance and you go through that route and you can understand how long that route is. So that is one part of it. So the whole concept of the Singapore Convention, of course, it only applies to the Singapore Convention as such, only applies to international commercial mediation. Only on that, first of all. I mean, that is what it's for. But the countries who are ratifying it are also looking at a domestic law on mediation at the same time, which is what is this in discussion, say, in India also. So while drafting that law, which is going to apply to the settlement agreements, which only are in a domestic settlement agreement, in that also there are discussions on regulating the profession, because it's an opportunity. Let me tell you, first of all, the Indian situation, because obviously you are going to be dealing with India and you are dealing with India. We have, like I said, a provision, a law relating to the act is called the Arbitration and Conciliation Act. In that, there is a portion called conciliation. So in that conciliation is, like I said, mediation. UNCITRAL was using the word conciliation when we took the when we took their model law and I mean, of course, we enacted our act, but it based on that model law. And UNCITRAL in the new model law for mediation has said we were using that word, but the mediation and conciliation are the same thing. So now we are moving to the word mediation. That's it. But it is a law on mediation. But at the other side, we have the word mediation also used separately in the same act. That in an arbitration, there is a provision that which says that it is, I would say, more of a duty of the arbitrator to see if there is a settlement possible, and the parties can settle it through mediation, conciliation, or any other method. So the point is, why these two words? The way of course, I mean, for being interchangeable, yes, they're interchangeable. The point is that if you have the conciliation process and you go through that, you get what that settlement agreement is as good as a consent award, which is as good as a court decree. So if you go through the conciliation and you get a settlement agreement, you don't have to come back into the arbitration. You're out of the arbitration. But if you use mediation, you still come back to the arbitrator passes the consent award, and then it becomes a court decree. So those two words are important. Otherwise, even if you're not in an arbitration, otherwise also the two words are important, because like you know, at least in India, contracts can be verbal. So you get into a mediation, which I'm calling the word mediation here. You have a mediation which is nothing. There's no regulation on it, nothing at all. Do it the way you want. At the end of it, you will only get a contract, be it verbal or written, and this is then enforceable as a contract, which means that you go through the process. While in the conciliation portion, you follow what is written there, nothing much, very basic, nothing much. You get the protection of everything, confidentiality without prejudice and everything, and that settlement agreement becomes as good as a consent award, which is as good as a court decree. So we have both the options, and both the words are required. For some reason, people are confusing this whole concept that there should be only one way to go about it, and that one way will end up with a written settlement agreement. In conciliation, you have to have a written settlement agreement, but that's not the way mediation happens. People can obviously agree to things and not put it in writing. So I don't know. I think there is a confusion there in terms of how the process has to function, at least in our country. I think that part of it needs to be discussed, because the law is being drafted, the bill is being drafted right now, and these issues will come up, I think, because that is why I said regulating the profession, because I had in that, with this show that you're coming on the 9th, in conversation with the beautiful mind. Thank you very much for doing that, and thank you, Natalie
Thank
and
you for
Jean and
inviting
Suresh.
us. Yeah.
It'll be nice, and I've been, like I said, I've been wanting to do it, but the last 2 months, your Thursday thing is clashing with my Thursday session of the symposium, so I haven't been able to do that. But the point is that in that conversation, one of the episodes, I had a discussion with Hiro Aragaki, who obviously talks about the fact that the US doesn't regulate it. Anyone can be a mediator, anyone can do about it. So, and I feel it's perfectly all right. But how do you look at it?
I think there are many ways to look at it. In the commercial and business context where I largely operate, I cannot see a purpose for regulation or licensing of mediators, because the selection of mediators is made by sophisticated consumers, lawyers. And the lawyers can do their due diligence on us. They can ask around within their law firms, within their bar associations, ask other lawyers they know. They can ask mediators for references. So there's plenty of ways for lawyers to make fully informed, or adequately informed, shall we say, decisions as to which mediators they want to use. In family law, it might be a different situation, because there, the hiring decisions, a lot in the United States, I think the statistics are over half of the people getting divorces are not represented by lawyers, because it's just too expensive. So there, the hiring decisions are being made by the consumers themselves. And there's a stronger case to be made for some kind of regulation or licensing where the professionals are being hired by consumers rather than being hired by other professionals. So I think that, again, in the commercial and business area where I transact business largely, I can't see the reason for it, and all the usual critiques, making it more difficult for new entrants with innovative ideas to come into the field. And the field would benefit from disruption from time to time, as most fields do. And the incumbents, people who've been doing it for a long time, like myself and perhaps you, Vikram, well, if new people are coming along and challenging us and making us less complacent and making us read new things and learn new things and keep up with developments of whatever type, well, I don't know that that's such a bad thing. So, in fact, I think it's probably a good thing. I enjoy learning and improving and figuring out that there's always a new frontier and a new horizon of knowledge and skill to accomplish and to master. So I think that regulation and licensing, at least in the commercial arena, I would vote thumbs down. In the family, domestic relations, matrimonial arena, I don't really have a view, but I can see where there would be other considerations to take into account.
And also, Jeff, there's a certain school of thought on the certifications and the accreditations and the training part of it. But then Andrew Miller comes and tells us that there are 18,000 mediators in the UK and only 500 have work. So that accreditation did not translate into work for them. So what do you think about this whole process of accreditations and certifications and trainings? What is your view on that?
It's a pretty good business if you're the one giving out the sheepskin.
Exactly, that's what it's become. That's the only place where the money is being made, I think. So I think that okay, so that's it. I think that's okay.
I've never been asked, are you certified by this one? Are you accredited by that one? I have never, ever, ever been asked that. I'm asked, do you have some references? Have you dealt with situations like this with person? A better question than have you dealt with a situation like this is, have you dealt with personalities like this? And I wish people would ask that more. I'm dealing with these kinds of people, these kinds of interpersonal dynamics. I think that those are better questions to ask than, are you familiar with section XYZ of the statute that governs this or that field of law? You know, Vikram, there's a saying in the United States, I learned this in law school. You know the difference between a novice and an expert in any field of law? You know the difference?
You'll have to tell us what you have.
48 hours. Because if you're a good lawyer and you get good briefs from the lawyers involved, and a mediator doesn't have to be a lawyer. A mediator has to know, in the legal arena, you have to know a lot about law. But there are very fine mediators who are doing commercial cases who are not lawyers. They've picked up enough about procedure and evidence along the way that they can engage intelligently in handicapping cases. I'm a lawyer. I graduated law school in 1980. And you know, we've been around the block, Vikram. You've got gray in your beard. I've got gray in my hair. If you get good briefs from good lawyers about anything in an area of law where you have some reasonable amount of familiarity, within 48 hours and the benefit of an internet connection and the free research that's available so readily to us online, in a couple of days, we can learn enough about the little tiny wedge that's involved in any particular case in order to be able to participate intelligently in the discussion of the merits.
Absolutely. Yeah,
and,
exactly. Yeah.
And so that's how I think it works.
Exactly. I think that's what people have to understand. I mean, that picking up that subject knowledge doesn't take time. It doesn't take time at all. It's just you have to have that bent of mind, the kind of things that you can understand from it. That is more important.
Yeah. Now, if you've never done a construction case, or you've never done a patent case, or you've never done a products liability case, or you've never done a medical malpractice case involving certain kind of injury, for example, then yeah, I can see where nobody's going to bring you a super complex case in an area where you know nothing and you have no experience at all. But assuming you have basic grounding in the field, you can handle pretty complex cases on pretty short notice because you have the lawyers who are educating you and you have your own knowledge of mediation processes, your own insights into human nature, your understanding of how court systems operate, evidence and procedure. These are the things you need.
Exactly. So Jeff, of course, thank you for taking out so much time, but please, any concluding remarks just on the future of mediation, on whatever your wish, anything.
Vikram, you're the future of mediation. You're doing so much to promote it, particularly in India, promote mediation in a responsible way. And this is going to have ripple effects throughout South Asia, throughout uh, all the English speaking world, and any place you can get this translated. You're having your guests are from on the symposium, your guests are from all over the world, from different cultures, different legal systems. You're doing so much to educate and advance the field that I really want to thank you for all the work that you do and all the wisdom and scholarship and integrity that you bring to your work and beyond that to the entire mediation field. So thank you, my friend.
Those are very, very kind words, Jeff. That's really nice of you to say that. Because I don't, I mean, I just keep doing this. I don't even know whether whether people watch, don't watch. I just have to put it out. And I think maybe I put a little too much content out there, maybe, but it's all out there. I just have to keep
Yeah,
doing it.
people will watch what they're interested in. The more you put out there, Vikram, the more that will be of interest to somebody. Person X might be interested in this, but not that. Somebody else will be interested in that, but not this. The more you put out there, the more choices, I think the more of a service you're providing.
Yeah,
It's
but
wonderful.
you can see about almost 100 sessions of this is all out there. Then the evolution of a mediator. There are that series goes on. In conversation with the beautiful mind goes on. Now I'm starting a new series of lecture series because I said there has to be the best in the world. Let's put them out. Let's put it on the YouTube channel. Let everyone be able to get the benefits. So Ken Cloke starts that off on the 6th. Then there's the
Oh,
series called Talking Books, which I'm starting. Again, Ken Cloke's he kicks off my everything that I do. That evolution of meter, he was the first one there. This session, this symposium also, his was the opening address. So these two things are happening. So I'm going to be putting out a lot of content out there. I mean, I'm just enjoying it. Just these conversations, just having a conversation with you is so nice that
yeah,
this
it's
is what I
fun.
enjoy. Exactly. What happens if people watch it? I'm very happy, even if
I
they
hope
don't.
some people, Vikram, I hope some people watch it.
They
Even
will.
if not, it's just a joy to spend time with you. Thank you so
That
much.
was well. So thank you very much, Jeff, and I'll see you on the 9th. And if you can
Very
come
good.
tomorrow, if you can come tomorrow for the closing session, it'll be nice.
I'll do my best.
Professor
And I know
Sukhsimranjit Singh is there.
they're all recorded. Uh, they're all on
YouTube.
YouTube,
Yeah,
right? And you have Sukhsimranjit from Pepperdine on tomorrow. He's a gift.
absolutely.
He's wonderful, and that'll be very valuable to whether people watch it live, recorded, however. Everything he has to say is very valuable.
Absolutely. Yep.
Yeah.
So thank you very much, Jeff. So
Okay.
I just put the